Good morning to all of you. Welcome to Legal Matters by Sai Baba Sankara. Video number 1634. Right. Today we are going to discuss the case law on the dying declaration. So as per section 32 of the Indian Evidence Act, the person who is likely to croak or the person who is likely to die, if he gives a statement, it has got evidentiary value. It is an exception to hearsay evidence. This much you know very well. Lot of judgments. Pakala Narayana case, very famous case, you all know. Now please remember here, the Supreme Court stated that the dying declaration cannot be discarded merely because there was no extreme emergency at the time of recording the same. That means here the patient died after 1 month or so. Right. You can see the case as State of Uttar Pradesh versus Subhash alias Pappu, 2022. So while disposing this case in Criminal Appeal number 436 by 2022 on 1st April 2022, just 2 days back, you can see the citation in Live Law 2022 SC page number 336. Two judges, M.R. Shah and Madam B.V. Nagaratna. So they held that the DD cannot be rejected or cannot be discarded merely because there was not extreme evidence emergency at the time of recording the same, because of course it is the medical officer who has to send intimation to the judicial officer whether DD is necessary or not. So you can't decide. Merely since there was a delay in his death, there was no extreme emergency circumstance, you cannot say. Right? The procedure whenever a person gets admitted in the hospital, number one, when it is a medical legal case, number two, when the hospital intimation, it will be having, the admission intimation will be having 7 columns, out of which the last column is whether DD is necessary or not. If in the view of the medical officer, if the dying declaration is necessary, that means if he is not sure whether this man will survive or not, then he can send intimation to the local magistrate. The magistrate will come and record his dying declaration. Suppose if he dies, it has got relevance under 32 of the Evidence Act. Otherwise, it is only a statement given under section 161 CRPC. That's all. Right. Here, better the facts of the case. Please remember, on 4/12/1980, right? So, some persons, that is Subhash and 3 other persons, came to the shop of one Hari Singh. Came to the shop of one Hari Singh and asked him, maybe rowdy persons, asked him to give the free sugar and kerosene freely. So the deceased, Bangli, his name is Bengali. The deceased, who was working as a servant in the shop of Hari Om, he refused to give them. Of course, on the instructions of the owner only, he refused to give them. So immediately, irked by this, these Pappu and others stabbed him with a knife, gave him a knife blow, and also kicked him with hockey sticks, as a result of which he was admitted in the nearby hospital. And he gave a dying declaration on 5/12/1980, the next day. Right, the police came and the local magistrate also come and recorded the dying declaration. But please remember, after 30 days, he died. After 30 days, he struggled for life for 1 month or so. Later, he died. Okay. Now, the case was charged against them under section 302, main sections 140, so many sections are also there. But the case ended in conviction in 302, and this man, Pappu, was given life conviction, whereas the others, Madan Lal and others, they were acquitted. Trial court convicted this man. So normally he goes for appeal. Luckily, in the appeal, this Pappu was acquitted because the injury which caused death is done with a hockey stick. But that hockey stick is used by other persons. This man is allegedly stabbed him, but that stabbing is not actually sufficient to cause death of the person. So High Court has taken that view, and therefore, since the injury is not sufficient to cause the death, he cannot be convicted on 302, therefore acquitted him. Now the matter came to the Supreme Court. Here, two important points. Actually, two important points are there. Number one is, of course, we are not necessarily let us concern ourselves about the dying declaration. Please remember, here the point for concern regarding the dying declaration, the arguments on behalf of the accused person is, that is appellant, is that, please remember, the time-bound limits for the dying declaration cannot be established, because it is the medical officer who is having known the present condition of the patient. Yes, definitely he can ask for the dying declaration. Regarding the dying declaration, sending requisition is the job of the medical officer, but not that of the investigating officer. And that too, there are certain people who die immediately. There are certain people who take so many of time. If the medication is good, he may survive also. If he survives, what happens? It is only 161 statement. It will be subjected to cross-examination. So many contradictions, so many omissions, we can take it out, is it not? So, merely because there was a delay in the, delay in the death, or in other words, the appellant, they argued that there was no extreme emergency at the time of recording statement. Court did not agree. Ultimately said it is for the doctor to decide as to when the DD has to be recorded, and this delay will not give any hurdle to the dying declaration. So since he died, basing on the DD, once again, this man, the conviction given by the trial court is upheld in the Supreme Court. Good judgment. Please read it and enrich your legal knowledge. Thank you.